Welcome to Bruce Hurwitz Presents Meet the Experts. I'm your host, Bruce Hurwitz of Hurwitz Strategic Staffing. You can find us on the web at hsstaffing.com. I hope you'll consider us for all your staffing, career counseling, and speech writing needs. Today I am joined by Eric Sarver. We will be discussing employment law issues in the time of Corona, minimizing employers' litigation risk. Meet the Experts is sponsored by P&K CPAs. P&K is a full-service accounting firm. They provide accounting and consulting services to businesses ranging from startups to small and mid-cap companies to nonprofits as well as high-net-worth individuals. Contact them today for a free consultation at pk-cpas.com or call them at 973-882-8810. They will be happy to be of service. Eric, welcome to the show.
Bruce, thank you. It's good to be here. Thank you for having me.
My pleasure. Most people, but before we get started, please take a minute or two and introduce yourself to our viewers.
Certainly. Hello, everyone. My name, as Bruce said, is Eric Sarver. My law practice is the law offices of Eric M. Sarver, and I practice employment law and labor law, as well as business law for small to mid-sized companies, business owners, and nonprofits. My practice covers the gambit from defending employers in court or arbitrations, to compliance, helping you to proactively make sure you're following all the different labor and employment laws out there, to drafting employee handbooks and contracts, and business law matters. So that's a little bit about me. Very happy to be on the show. And again, Bruce, thank you for having me.
My pleasure. Now, most people, when they think about the coronavirus, think about the accounting aspects of it if you're a business owner. But there are a lot of legal issues as well. So let's take them one at a time. And the question really is how to keep, how employers can keep themselves out of trouble, fulfilling their legal obligations. So let's start with something called the FCRRA. What is that?
Sure. It's a great place to start, by the way. It's one of the initial legislation that was passed. So the FCRRA is the Families First Coronavirus Response Act. And what that is, it's a multifaceted piece of legislation, but as it relates to business owners from an employment law context, it provides for certain protections. For example, that employers must provide emergency paid sick leave to those who are needing to take off from work due to COVID-19, certain conditions that I can come back to in a moment. It also involves and includes expanded emergency FMLA. So what it basically does is it also allows for and provides employees with an expansion of the FMLA rights, where they're actually getting paid leave. It's actually 10 weeks of paid leave at 2/3 of the salary, plus 2 weeks of non-paid. So basically, the FCRRA is legislation that provides employees with certain rights and obligations, and it's directly related to COVID-19. So employees, for example, who have to stay home to take care of a child whose daycare or school is out due to COVID-19, those who have lost the head of a household or themselves are under quarantine, and it allows for these type of protections for employees, and therefore it imposes certain obligations onto employers.
Now, how does that relate to the CARES Act?
It's another good question, and I'm not just saying that here, because they very much overlap. So, well, the CARES Act has a number of different components and facets to it. So we have the CARES Act, we have the Families First Coronavirus Response Act, and then we have the subsection of the CARES Act, which has to do with unemployment insurance, things like pandemic unemployment assistance. To answer your question of how they relate, both provide different types of legal obligations for employers to follow with respect to their employees. The CARES Act provides for two types of things for business owners. One, it expands and enhances unemployment insurance benefits for a company's workers, for their employees. So it increases the amount of unemployment per week. It extends the amount of weeks of unemployment insurance that an employee may be entitled to, and it also opens up the bandwidth of it. It broadens who may receive unemployment insurance. But that's just one part of the CARES Act that relates to the Families First Coronavirus Response Act. Another part that relates has to do with certain stimulus relief. For example, business owners, I'm sure perhaps people might know by now, can apply for and receive the Paycheck Protection Program called the PPP loan, which is basically a loan with a very low interest rate, the majority of which, 75% of which, can be forgivable if an employer meets certain obligations of keeping a certain number of employees on payroll for up to 8 weeks, keeping people from furlough, or rehiring them back. So really, all of these different laws, Bruce, tend to come together to provide two forms of relief, really. A, different types of loans or money or stimulus relief to the business owner, a small business of 500 employees or less. And B, at the same time, it imposes upon businesses certain obligations with respect to their employees. I think the idea is to marry these two in a concept that we want to encourage businesses to keep their employees employed, keep them on the books, not to be letting people go and trigger a worse recession. So there's this incentive and there's this money being given, but with that comes certain obligations to the employees as well in recognition of the challenges that COVID-19 presents.
Now let's forget about the money,
Mm-hmm.
the financial aspect, the legal aspect of it. Why is any of this really necessary? And now we're focused on New York State, where you have employee sick leave, you have the Family Medical Leave Act, and you even have furloughing and rehiring of employees. So the existing pre-COVID-19 laws, weren't they good enough?
So I see what you're saying there. Yes. Well, there are 2 points I'd make to that. The question of why do we have this relief when we have all these other forms of relief, other types of a safety net, if you will, for employees. The first point is that the emergency paid sick leave and emergency FMLA leave, that actually is on top of, it can be concurrent with some of the employee protections and some of the leave that's paid under New York State law. So for example, somebody can be collecting quarantine pay at a rate of their salary if they're under quarantine order and still be collecting emergency FMLA leave. I think the reason why we need the federal is for 2 reasons, right? One, let's recall that New York State is a very generous and liberal state when it comes to employee protections, but the federal legislation covers all 50 states. So some states, for example, are not as generous as, let's say, New York, California, or Oregon might be. So the reason to have both is for 2 reasons. One, to provide as much relief as possible to the individual who might be, for example, sick with COVID-19 for 2 months, or may have lost a head of the household from a death to the illness. I think the goal is to really try to compensate people and also to encourage businesses to keep people on the payroll. And also there are, the last thing I'd tell you, that there are different forms of tax credits that businesses can receive if, for example, they implement the emergency paid sick leave under the federal law, and there's a different type of tax credit that they can receive, they being the employers, if they implement the New York State on-pause legislation. So really it's a matter of combining, and that's, I think, the reason why we have the additional federal legislation. That's why New York State was not exempted from the federal law.
Let's move on and focus for a few minutes on employees. Now, let's be honest, people are scared. Sometimes the fear is justified, sometimes it's not. An employee makes a request to their boss to work from home, let's say, and they can do their job from home remotely, but the employer doesn't want that. And the employer says, look, you can walk from your home, you never take the subway, so you don't have to worry about getting on the subway. And we're on the second floor of the building, so you can take the stairs. You don't have to take the elevator, so you don't have to worry about pushing the elevator buttons or being stuck in an elevator with a number of people. And those employees who aren't as lucky as you and don't live nearby, they're working remotely. But I need some bodies in the office to deal with this, that, and the other thing. Can the employer, under those circumstances, with that scenario, force the employee to come to work?
I'd love to answer that question, and I'd love to give a simple yes or no. And I'm going to
You
give
can't give the lawyer's answer, it depends.
I'm not going to do the it depends, but I'm going to say this. I'm going to say, in the scenario you presented, where the employees, you've demonstrated that the employers kept a safe work environment and there's not a risk to the employee, and the employee is able to get to work and the employee is needed at work, I would say that, generally speaking, the employer has the right. I won't use the phrase, Bruce, it depends, but I'll say this. Short answer is an employer can request employees to come into work. And this is going to be a bigger issue now as more and more non-essential businesses start to reopen, right? You've got workforces that cannot always be remote. Sometimes you need people, like you said, bodies in the office. Other types of jobs, for example, a customer facing or a restaurant, you can't telecommute to a restaurant from home if you're a waiter. So an employer can require their workers to come in, but what's important to keep in mind is that there are other conditions in that scenario where the employee may object, and you have to look at, you being the employer, need to look at what is the basis of the employee's objection. Because here's my concern, here's what I tell my clients. The scenario you gave, it's an excellent example, and sure, employers have a right to say, hey, I need you in the office. And if the employee just says, well, I don't want to come into work because this whole COVID-19 thing is crazy, it's dangerous, I'm reading about it, you have to assess as an employer at that point, what is the basis, what are they really saying? So you need to dig deeper. If it's, I don't want to come in because, yeah, Bruce, I live 3 blocks away and the place sounds safe, but I have asthma, you see, or I have a chronic pulmonary condition, or, you know, you may not have known this about me, but I have diabetes, and diabetes and my other conditions makes me highly at risk of COVID-19. Well, then you might be looking at, are they asking for a reasonable accommodation request? Is this an potential ADA matter? Are they saying to you, I need an accommodation to work from home remotely. I'm disabled by way of state and city statute. The ADA hasn't quite ruled whether that's a bona fide disability, but guidance has been given by the EOC to say that if you have a pre-existing condition and that makes you more vulnerable to COVID-19, that could be a ADA bona fide disability. So that employee might say to you, I'm sorry, I'd love to come in and be a body in the office, but I need this combination to be working from home. Now, then you have an analysis to make, which I'm sure we'll get into in further questions about they're working from home. Well, can you afford that? Will that create an undue hardship for you as the employer? Can you offer an alternative accommodation request? Hey, listen, I'm sorry, Joe. I'd love to do that, but I need you in the office, as you were saying. Can we stagger your shifts? Can we put you in your own private office? Can we give you a private separate bathroom? So really, I think it depends upon what the employee's stated reason is for not wanting to come in. And if it's a, hey, this place is unsafe, I haven't seen any cleaning going on, no one's wearing masks, then you might be looking at a possible whistleblower. See, so short answer is, it depends, but in most scenarios, that employer has every right to say, yes, you can come, you need to come into the office, I need you here. But I always say we need to pay attention to what the reason the employee is given, and that will help frame the issue, and that'll help frame your response as an employer. What do I do? How do I address the situation? Do I fire the person? Do I capitulate automatically? What's in between? And that's kind of how that fits into the picture.
Now, how does the ADA, which is the Americans with Disabilities Act, how does that relate to the National Labor Relations Act? And since we're talking New York State, the whistleblower protection statutes.
Sure. Well, I think one thing that all have in common is that all of those statutes, the ADA, the Americans with Disabilities Act, which by the way is a federal law, and there's also a comparable state, New York State human rights law and New York City human rights law. But the ADA, Bruce, and the, let's take the New York State Whistleblower Act and the OSHA, and I think the third one you mentioned was?
The whistleblower.
Correct, yes, right, whistleblower, OSHA, and the ADA. The way that they relate is that they all have protections built in against retaliation for an employee. I think you mentioned the NLRA was the third one also. They have protections built in for employees who engage in certain types of protected activity, which looks different under each statute. And so there's a correlation that you as an employer may have to make certain accommodations, or may be forbidden from taking some sort of adverse employment action against a person, and that's kind of how they relate. So it might be even clearer to explain by example, like perhaps 3 short scenarios, if you'll indulge me.
Please, go right ahead.
Okay, wanted to make sure I was answering your question directly here. So, for example, the ADA requires that if an employee has a disability and cannot, let's say a disability is preventing them from coming to work in the office, or they ask for an accommodation. They ask, let's say, for a shorter shift because they need to go home and tend to their disability. Let's take it in the COVID-19 context. Let's say they are asking for a change in duties. I'm a frontline customer interfacing person, but I also have this condition. It's a disability, and I can't be at risk of COVID-19. So I'd like to be in the back office crunching the numbers. I'm qualified to do so. That brings up an obligation from the employer to assess, can I make that switch? Can I make that accommodation? And that employer also has to be very careful. If they fire that person or demote them for making that request, it can be seen as a form of retaliation. Now, the National Labor Relations Act has to deal with, think about an employee who, let's say, has COVID-19 fears, concerns, and maybe they're not disabled. They're perfectly healthy. They're 25, they're in great shape, but suppose they are objecting to coming into the workplace because of unsafe, or what they see as unfit conditions, right? They're trying to advocate for a better work environment. They're trying to advocate for more masks. Boss, we need more PPE. You've got to get us hand sanitizer. I don't want to come to work. I won't stay here if you don't make these changes. That can be basically bringing up their protected right under the National Labor Relations Act, the NLRA, to essentially advocate for themselves and their other coworkers, right, for a better working environment. And so when you have that type of activity, right, that complaint, that speech, that request to improve, you as a boss have to be very careful, because if you get angry at that person and let them go, say, hey, this person's a troublemaker, I don't need this aggravation, you can be charged in the NLRA with violating their rights because you've unlawfully retaliated against them. You fired them based on their protected activity. And lastly, the whistleblower action is very similar. Here I think about an employee or someone at the workplace who is essentially complaining to management, or maybe even complaining to a local news media outlet or a public government watchdog agency and saying, I think this place is unsafe, I think this is dangerous, and here's what I've noticed, and here are the violations of safety that I see, the hazards, and I cannot work on these conditions. I want you to change these. And then when the employer fires that person, if they fire them based on those complaints, that can be another liability. So really all of these statutes that you've asked me about all have potential for liability for the employer. So I always say it's important for the employer to have a plan of action when faced with these type of scenarios. Now,
in my experience, the most important protection that an employer has in their relations with their employees are first and foremost the personnel handbook, which probably won't be all that helpful in the current circumstances, and documentation. What type of documentation do employers have to keep to protect themselves?
Excellent question. Bruce, first I want to say I agree with you. I think the employee handbook is a very key document. It's something that we employment lawyers see as almost a form of a sort of Bible of sorts, for lack of better terms, for your business. And it's very helpful for providing guidelines and providing what the law requires. It provides lots of different types of liability protections. Now, I'll get to the documentation in a moment, but if I may note that this is an ideal time for employers to start to ramp up or enhance their employee handbooks. If you don't have a policy around handling illnesses in the workplace or communicable diseases, this is a great time to have that in place. If you don't have a statement of your compliance with the CDC guidelines for a safe work environment, again, excellent time for that. But your question to me, Bruce, and I appreciate the question because it's a lot of what I do for a living. You asked me what type of documentation, right, should an employer have in place? Can I clarify the question, if I may? What type of documentation by way of when an employee is coming back if the employee voices objections, or just more generic documentation, let's say a business is getting back on its feet or reopening their shuttered doors? I just want to understand the question.
Well, the scenario that you've painted is one where the employer requests the employee to do something, and the employee objects, and then the employer, in order to be able to provide the services that he needs to his or her clients, customers, what have you, they let the person go. Or you gave the example of demoting them. Maybe you get paid more if you work in the front office than you do in the back office. So now the person's asking to be transferred to the back office. That's all fine and good. So Sally moves to the back office, and now Joe has to move to the front office. So Joe is now going to earn what Sally was earning, and Sally's going to get what Joe was earning, which is less.
Right. So what kind of documents do you need in place? Right. So I think the most important thing here to do is following. There's documentation that businesses need going forward to basically put out to the employees what the business is doing to keep the workplace safe. So that's one form of documentation. This is sort of the leading up to the scenarios that you've mirrored back to me, which I presented to you. There's documentation around following of CDC guidelines. For example, you want to let employees know you need documentation to show employees that you are complying with social distancing, complying with providing PPE masks, complying with posters for OSHA in the workplace. But if you are making that termination call because the employee just says, I can't come in and you need them, or if you are turning down that accommodation request, you need documentation. First, you need documentation to show the good faith efforts you have made as an employer to meet an accommodation request in the ADA scenario, the disabled employee, or you need documentation to show that you have addressed an employee's concerns. Let's take the potential whistleblower case scenario, or the potential NLRA violation. I think it's important to have documents, Bruce, that you have spoken to your employees, you have memorialized in writing their concern, usually with an HR person present, or if you don't have an HR department, a second witness and manager. And you want to make sure that you're addressing their concerns. So you want to be sure that you are documenting their, whatever their objections are, let's say they're coming in. You want to make sure that you are then providing documentation of what you've done, if you need to do anything to remedy a dangerous condition in the workplace. And you need to also confirm that, let's say you have to let somebody go. Suppose they're just not showing up. that could be considered job abandonment, right? You can't do your job if you're not there, or if they're missing too many days. You need to document the legitimate business reasons that you're letting them go. So, for example, you need to have summaries of meetings with these people, or warnings, or you need to have some kind of documentation, some kind of paper trail, so that if you ever are sued, or you get a demand letter from a plaintiff's attorney, or maybe you get a letter from the EEOC, someone filed a complaint against you, that you're in a better position to say, hey, wait a second. We, in fact, did address this person's concerns about the workplace. We demonstrated that we had a safe workplace. Here's the documents we have to prove it. Here are the copies of CDC guidelines we gave to the employee, number one. Number two, here's a copy of our workplace return to work safety policy, right? Number three, here's a copy of a couple of memos of conversations we've had with the employee. If you have a disabled employee seeking an accommodation, you need to gather medical documentation. What is the disability? What is the accommodation request? Is it medically required? Will a doctor back this up? Because if an employee says to you, hey, I have athlete's foot and it's a terrible itchy condition, and take my word for it, that makes me more vulnerable to COVID-19. I've never heard of that. So perhaps you haven't either. So you might want to say, well, listen, if you can get me a doctor's note, I'm a real doctor, that shows that link and says that you need an accommodation of a shorter workday or a back office, you would need that medical documentation as well. So there are documents you need. It really depends on where you are in the situation. You want to, the name of the game is minimizing employer liability and minimizing risk. So there's documents you need when an employee makes a request to show that you're taking their request seriously. There's documents you need to have employees prove to you their circumstances that might require a certain accommodation, whether it's, again, working shorter shifts, working from home, not commuting altogether. And you also want to document how you're making the workplace safe. And lastly, what actions you've taken with respect to employees. So if you do need to let somebody go, if you do have to terminate an employee, and they're still trying to stay on unemployment insurance, or they're threatening to sue you, you know that you at least could show that, hey, what they're alleging is not the case, right? They may perceive they were fired because I felt threatened by their complaints about the workplace being dangerous, but in reality, I've demonstrated to them and to you, the court, and to you, the board, wherever you might be situated, but I have a very safe work environment. And so there's no objective grounds for claiming this is unsafe. And I say that word objective because for New York State whistleblower cases, it's not enough to have a perceived impression of a violation of the law. There needs to be an actual violation of safety, public safety or hazard that exists. Unless you're in the healthcare industry or hospitals, EMTs, that's a different law that covers those things.
And that, what you've just advised, will protect employers from frivolous lawsuits.
I think what I advise will further increase their protection. Yes, and I'm glad you said protect, because it'll protect, but it's not 100% insulation from the fact that you could get sued. You know, often people ask employment lawyers, okay, if I'm going to hire you to help me get in compliance with the laws, that means that I'm not going to get sued, right? Or that means I'm not going to have ever a question come up with the Department of Labor, right? And I always make it clear that I can never guarantee that, and nor can anybody, right? It's just not.
Anybody can sue for anything.
Right. Sadly, that is the case. But, you know, people do say that, and it's interesting because that plays into some more recent claims for tort reform and for liability protection. But yes, people can sue for anything, but there are actions you can take that will improve your chance of having their lawsuit dismissed, thrown out of court quickly. Maybe on what's called a motion to dismiss or motion to summary judgment. There are actions you can take that will show the strength of your case and therefore devalue the plaintiff's case both in their eyes and the eyes of their attorney. So if they have an attorney and the attorney hasn't done their homework, and then you present all this evidence medical notes, that documentation that you've offered reasonable accommodations, proof that you can't accommodate the person that you tried to, you might find that a plaintiff's attorney who is working on contingency might suddenly back off. I've seen this happen with opposing counsel, or might be looking for a nuisance settlement. And then you need to decide as a business an economic question of, do you pay a nuisance settlement to save time, money, energy on defending from something, or do you fight it on principle? But basically, you're correct that what you are saying, and what I'm saying, is that these steps that we take are to strongly minimize the risk of liability, and to note that if there is any liability, you'll shrink the chance of being found liable, essentially, of a wrongdoing.
Eric, I want to thank you profusely. And before I let you go, I want to share your contact information with our viewers. I appreciate you having taken the time to come on. Thank you.
Bruce, thank you so much. My pleasure. It's been a pleasure to be on your video podcast, your show. I look forward to perhaps future times where we might do this again. And thank you for your good questions as well.
It will be my pleasure. Thank you.
Okay, thank you, Bruce.
I'm Bruce Hurwitz. Thank you for watching. And as always, please stay focused on success.